Good morning. My name is Robert of the Johnson family. I'm a law scholar and author of Sui Juris, The Law of Full Age, your sovereign claim to unalienable individual rights. I'm posting this as a video response to the hit piece produced by retired former Chief of Police of the West Memphis, Arkansas Police Department, Robert Paudert, depicting sovereign citizens as terrorists. I am not a member of the sovereign citizen movement, so I cannot speak to their beliefs. My concern is how all people who use the term sovereign are grouped together, and police are being taught that they are all violent extremists who do not believe they are required to obey the law. This video released by Robert Paudert is self-admittedly biased, as his son was murdered by two sovereign citizens during a traffic stop. I will now clear up the confusion so there is no further misunderstanding. An entire school of thought is not wrongfully criminalized as terrorism/paper terrorism. First, I deplore the violent actions of those men claiming to be sovereign citizens. They are not sovereign, they are criminals. Terrorists, no. Murderers, yes. I express my condolences for Mr. Paudert on the loss of his son, and to the entire department of the fine men and women of the West Memphis Police. I address this to both Robert Paudert and Donald Oakes, the new chief of the West Memphis, Arkansas Police, as a friend to law enforcement, not an enemy. I will support all of my positions with citations of long-established law. I will try to remain as non-confrontational as possible, but I take great exception to being labeled a terrorist for simply using lawful and peaceful means to claim and exercise, assert, and defend freedom for all individuals. Mr. Paudert has good reason to be angry. His son was murdered by criminals. But law must be unhindered by excessive emotions. It is certainly fair to arrest and bring to trial, as well as carry out any sentence handed down by a court, the men who are responsible for the death of the two fine officers. On the other side of that coin, though, it is both improper and unlawful to criminalize people who are not doing anything unlawful. Being that I am not a sovereign citizen, I cannot speak to the beliefs of that group, but what I can do is express my sentiments regarding a great many points of confusion between law enforcement and the people. It is absolutely true that there are Americans who believe they are sovereign, and rightfully so, as all Americans are equal, and all the highest authority over themselves. We are all indeed sovereign, individual kings and queens with equal rights to that of our former king, including the right of self-governance and allodial ownership of property. Self-governing sovereignty is a birthright, established clearly by law. In the laws of New York, the state I inhabit, Article 2, Bill of Rights, supports this: supreme sovereignty in the people. No authority can, on any pretense whatsoever, be exercised over the citizens of this state, but such as is or shall be derived from and granted by the people of this state. The right of self-governance and sovereign sui juris action is absolute and grounded in long-established law. That being said, the term sovereign citizen is an absolute joke, a complete oxymoron equal to obligation of law to agree. One is either sovereign or a citizen. You cannot be both at the same time. Citizenship itself is a voluntary contractual relationship where the sovereign exchanges all of their natural rights at law for a limited liability protection privilege at commerce. These are known as 14th Amendment Maritime Admiralty privileges. They mimic rights, but are not rights. Liberty is not freedom. Liberty, by historic etymology, is a privilege in maritime admiralty law, the law of water, which a ship captain would grant his crew upon arriving ashore. Liberty is akin to shore leave. Freedom is a birthright and is the law of the land. This is why the Statue of Liberty appears in the harbor. It could not be built on land. It is not the Statue of Freedom. It is a symbol of maritime admiralty law. A sovereign inhabitant is a lawful free adult of the age of consent, whom exists here lawfully by right of birth, and has entered into no privileged registration contracts with civil government, or whom has revoked their signature and consent to such contracts by notice due to mistake of fact or constructive fraud and duress. Most of what people in this country call law is not actually law at all, but the terms and conditions of these voluntary civil adhesion registration contracts. It is the position of the West Memphis, Arkansas Police Department that sovereign citizens believe they are not obligated to obey the law. This could very well be true. I do not know one way or another. Everyone is required to both know and obey the law. True sovereign inhabitants make it their duty to keep and uphold the law. My concern is that we distinguish the difference between the lawless criminals that hide behind the law, the Constitution, and the law-abiding people who study my work. Some of the positions appear similar, but only at first glance. Anyone who would use violence and physical lethal force in a non-life-threatening situation is a criminal. There is simply no reason for anyone to draw upon or fire at a police officer. If one is not intelligent enough to articulate, claim, exercise, assert, and defend rights without causing harm to another, that individual cannot claim and exercise the right, only the regulated privileges. The only duty payable to rights is to ensure that no harm comes to another. The information I advance centers around self-governance and the adult, mature, responsible claim and exercise of rights, which inherently harms no one. I only advocate lawful and peaceful action to defend our rights at law, to secure remedy for violations. My readers in my own battles are fought with a pen, not a gun. Bob Paudert refers to those who use notices, affidavits, and writs as paper terrorists, and those who do not use these only in good faith could be guilty of harassment, but not terrorism. This label of terrorism is nothing more than a modern-day witch hunt to discredit anyone who the police disagree with. Terrorism is always a violent act. It cannot be committed by lawful notice. The use of these notices is identical to the notices police use with respect to their violation tickets. So if I am a terrorist for using lawful common law discussion to avoid conflict, so are the police every time they write a ticket. Sovereign citizens may use similar documents, so I do not want that group confused with my positions. Before any of my readers act, they will have secured a judgment in their favor of permanent estoppel by acquiescence, simply presenting them a color of right in whatever they wish to do, and establishing a shared understanding between the law-abiding American and law enforcement. This notice is not a prerequisite to rights. It is a courtesy. The West Memphis, Arkansas police hold the view that sovereign citizens believe they are above the law, as well as taxation. While that may be true of that group, it is not true of what I advance. All Americans are required to know and obey the law. That being said, no one is obligated to obey any unconstitutional act, or any act that in any manner violates or infringes upon a right. Any act of legislation repugnant to any right is null and void ab initio from the beginning, unenforceable by courts and police as if it had never been passed. My readers and I are duty charged by freedom itself to keep and uphold the law, the supreme law of the land, as all officers are. All police swear an oath to the Constitution, but ask them if they ever swore an oath to uphold the Motor Vehicle Code. This is where the confusion lies, in the differentiation between that which is statutory rule and that which is law. Statutory rules can be laws, but every time that is true, an element of harm to another exists. Without an element of harm to another, statutory rules only gain the force of law by individual signed consent via submission of an application for registration into some government privilege. This is where the source of confusion lies. voluntary obligations of privileged limited liability protection contracts are misconstrued as obligations of law when they are not. There can be no such thing as a mandatory obligation to agree. The very fact something is an agreement wholly negates the very possibility of it being a mandate, and refusing a limited liability privilege contract does not waive or in any manner nullify any fundamental right. Only accepting the privileges knowingly, willfully, and by fully informed consent can one lawfully waive a right in a contract, and the waiver of such rights cannot be imposed as a condition of a contract under duress. Any penalty, including a rescinding of a contract, for refusing to waive a right creates duress, which nullifies consent. One cannot give voluntary consent under duress in any form. As such, all of these contracts are void ab initio from the beginning. Just as a gun negates the ability of a woman to consent to sex, intimidation under color of law also negates consent. To explain simply what exactly is going on and how this all works, we will look at the Automobile and Motor Vehicle Code. What is about to be explained is true for all things. All properties, homes, boats, cars, snowmobiles, jet skis, pets, firearms, and it also applies to lawful activities, hunting, fishing, marriage, childbirth, voting, selective service, obtaining and using medicine, even Social Security, or the lawful claim and exercise of any other right. Examining the automobile, the moment you purchase a car, you own it absolutely in allodium. It is no different from a bicycle until you register it, which there is no obligation of law to do. There is no such thing as a mandatory obligation of law to agree to anything. No obligation to sign your property and rights over to the state in order to acquire the lawful authority to enjoy property and exercise rights. These are fundamental, unalienable aspects of freedom. Lawful authority does not flow from licensure. Licensure authority flows from ownership. Your driver's license is not permission to own property, nor to travel and transport your property and yourself upon the nation's commonways, any roads. Those are both fundamental, unalienable rights, long established by the courts. The right of the citizen to travel upon the public highways, and to transport his property thereon, either by horse-drawn carriage or by automobile, is not a mere privilege, which a city can prohibit or permit at will, but a common right, which he has under the right to life, liberty, and the pursuit of happiness. That's Thompson versus Smith of the Supreme Court, 154 SE 579. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of the public, which the public and the individual cannot be rightfully deprived. It's Chicago Motor Coach versus Chicago, Laguerre versus Chicago, and also Boone versus Clark. His rights are such as existed by the law of the land, common law, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure, except under warrant of the law. He owes nothing to the public, so long as he does not trespass upon their rights. That's Hale versus Henkel, 201 U.S. 43 at 74 from 1906. An unconstitutional act is not law. It confers no right. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton v. Shelby County, 118, U.S. 425. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it. No one is bound to obey an unconstitutional law, and no courts are able to enforce it. That's 16th American Jurisprudence, 2nd Section 177, late 2nd Section 256. A driver's license is solely permission to use state property, the car you abandoned to the state by act of registration. The state then happily seizes the abandoned property under maritime admiralty salvage and licenses use back to you under a privileged limited liability protection use permit, a contractual agreement holding the absolute ownership allodial title as surety against you for your compliance to the terms and conditions of the registration contract, which is itself the Motor Vehicle Code, in which you waived all rights in exchange for the privilege by your voluntary signed consent. The officer is not seizing and removing from the possession of the individual their property in violation of due process of law. The officer is removing the state's property from their possession. You waived your right to not be deprived of property absent due process of law. You waived the right to see a magistrate determining the lawfulness of your custody. You waived the right to be secure in your person, papers, and effects. So it is improper to say that sovereigns believe they are above the law. Some may believe that, but it is not true. The fact is, the Motor Vehicle Code is not law at all. It is a contract, a voluntary agreement. All activities that are licensed must be lawful outside of the licensing framework. Otherwise, the licensing body is licensing crime, unless one can go get a permit to do armed robbery. The only thing ordinarily unlawful being permitted is the use of property which you do not own. Each agreement relates to different code sections. The Income Tax Code, for example, is the terms and conditions of the voluntary Social Security registration contract. Title 42 of the United States Code, Section 405, C2BI, clearly establishes the voluntary nature of Social Security, as 26 CFR 31.3402 P1 establishes the voluntary nature of withholding at source, which also by your signed consent obligates you to the statutory rules of that code. Obamacare, also known as H.R. 3590, is implemented in the same way as voluntary withholding at source. There is no mandate per the bill itself in Section 1555. It is entirely voluntary. The sole reason there is hype surrounding exemptions from this program is to create the perception of a mandate that simply does not exist in fact or law. So it is also improper to say that sovereigns do not believe the government has the right or authority to tax. Some may believe that, but again, they are wrong. The fact is, there is no point debating what Congress can tax because they did not tax the earnings of the people. The Supreme Court ruled that the 16th Amendment granted no new taxing power to Congress, nor did it repeal Article 1, Section 9, Clause 4 of the Constitution. The 16th Amendment to the United States Constitution, as correctly interpreted by the U.S. Supreme Court, in such cases as Bresharber v. Union and Pacific Railroad Company, and Stanton v. Baltic Mining Company, identified the income tax as an indirect excise tax in accordance with Article 1, Section 9, Clause 4. The tax is only upon privileged source activities, which give rise to statutory groupings of gross income. All of these statutory groupings are identified by 26 United States Code, Section 861F1. I will gladly pay any lawfully apportioned direct tax or indirect tax for which I engage in privileged activities that are taxable. Earning a living, trading your labor for property for liquid cash, isn't even trade. There is no profit or gain. And this is a fundamental right. Only privileges can be taxed, not rights. Social security, commerce, and foreign activity is the privileged activity giving rise to income. Commerce is not to buy. It is not to sell. It is not to trade. Commerce is to buy and sell. It is not to buy, add value, and sell. It is exactly two steps, and this is what may be regulated by government. Private trade does not constitute commerce. Some more Supreme Court decisions. U.S. citizens cannot be compelled to register in and subsequently participate in government entitlement programs, as the authority to require such from citizens is a power which obviously lies outside the orbit of congressional power. And that was Railroad Retirement Board versus Alton Railroad Company, 295 U.S. 330.55. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. That's Miranda versus Arizona, 384 U.S. 436.491. The claim and exercise of a constitutional right cannot be converted into a crime. It's Miller versus United States, 230 F. 486.489. There can be no penalty or sanction imposed upon one because of this exercise of constitutional rights. Snare versus Cullen, 481 F. 946. Therefore, it can clearly determine from the decisions of the United States Supreme Court that the income tax is an indirect tax, generally in the nature of an excise tax. An excise tax is a tax levied on the manufacture, sale, or consumption of a commodity, or any various taxes on privileges often assessed in the form of a license or fee. In other words, it is a tax on doing something to property or on the privilege of holding some property or doing some act, not a tax on the property itself. The tax is not upon the property directly, but rather it is a tax on the transaction. Transactions exist only in commerce, not trade. The income tax is therefore not a tax on income as such. It is an excise tax with respect to certain activities and privileges, which is measured by the income they produce. The income tax is not the subject of the tax. The income is not the subject of the tax. It is the basis for determining the amount of the tax. Now to explain the distortion of the role of the county sheriff, or shire reeve. The sheriff is the oldest office under the system of common law and is an integral aspect of government in the state of New York. This is a direct quote from the Erie County, New York Sheriff's website. The sheriff is equal to president within the county, CEO of the courts. All municipalities and other local police in the county are under the command of the sheriff. The sheriff is the highest constitutional law enforcement officer in the county, whose highest charge is the protection of the rights of the people. The sheriff answers to the Constitution alone, and most state constitutions define their duty, including the care and custody of those pending court action, which by definition must include ensuring the cause of action against them is valid, containing an element of harm to another. The sheriff is supposed to be doing what I am doing, and has a duty to differentiate between statutory rules and law. All police are peace officers first and foremost, but they have a duality to their position. They are also civil policy enforcement officers that bind people to their registration contracts. You can hold them to their lawful peace officer status simply by exercising your rights at law and refusing privileges and contracts. Now that we know what law is and what is not law, it is clear why standing must exist in every case to see the inside of a courtroom. Without actual or justicable controversy or corpus delicti, there is no standing or jurisdiction for the court to hear the case. Only a complaining party alleging under oath an element of harm, a violation of rights, or fraud, or an officer observing a breach of the peace can give jurisdiction to a court to hear a matter. But there is one more thing: your consent. In matters that do not involve a complaining party alleging harm, your consent can confer jurisdiction where it would not exist without your consent. This is done by ignorantly claiming to stand under charges or understand charges. Understand does not mean comprehend. It means consent to stand under. So the moment you claim to stand under the cause and nature of the charges and proceedings against you, your consent confers jurisdiction to the court to enforce the charges. Many words people use in court do not mean what people think they mean. Guilty and not guilty, respectively, mean gilded and not gilded, that you are going to pay or you are not going to pay. You can destroy the entire illusion just by knowing and exercising your rights and asking questions. From violation tickets to criminal charges where there is no element of harm like possession, all of these cases have no standing, and standing must be proven, not merely asserted. The scope of the jurisdiction of the court, without your consent, is limited to its de jure purpose and cannot act in a de facto capacity. Meaning, without your consent, the court's power is limited to protecting the life, freedom, and property of the people. Those are the only matters that count. Some Supreme Court rulings. To adjudicate upon and protect the rights and interests of the individual citizens, and to that end to construe and apply the laws, is the peculiar province of the judicial department. The judicial power is the power to hear and determine those matters which affect the life, liberty, or property of the citizens of the state. That's City of Scapula versus Land, 101. Also, Nash v. Brooks, 297 NYS. Without standing, there is no actual or justicable controversy, and courts will not entertain such cases. That's Clifford v. Superior Court, 45 Cal. All of this leads us to the most important aspect of law: how you handle your affairs. Rights cannot be claimed by attorney or solicitor, but only by a belligerent claimant in person. That is the entire purpose of my book, Sui Juris, the Law of Full Age, your sovereign claim to unalienable individual rights. Hiring an attorney is the absolute worst thing one can do. That is, hiring them to represent you. It is fine to hire an attorney to provide you assistance of counsel, but you do not want them to speak for you. Men and women are signing their future over to individuals who have sworn an oath of allegiance to the Crown of England in exchange for a noble title, Esquire. The attorney for the defense, the judge, and the prosecutor are all on the same team against you. It is 3-on-1. If you think you are getting a fair hearing, you are sorely mistaken if you have elected a status of representation. Both pro se and pro per are stati of representation. One does not represent themselves in court. They are themselves. So anyone who claims a status of representation is clearly not of sound mind or is of child mentality status. This means anyone who elects a represented status has declared themselves to the court unable to appear the only way a sovereign inhabitant in their own right can. Sui juris, of their own right/law. I use right and law interchangeably because laws are rights, and rights are laws, a fact the bar would greatly appreciate being lost to history. The British Accreditation Registry is the bar. It is owned by England. Even the American bar is merely a franchisee branch of the British Accreditation Registry. It is the American British Accreditation Registry. Every member of the bar swears an oath of allegiance to the Crown of England in exchange for a noble title. That in itself is evidence of ineligibility for one to hold an office of public trust or profit lawfully in America. One must swear an oath of office to the Constitution as a requirement of taking office. If you already have an oath of allegiance and a noble title evidencing that oath, you would be committing perjury to swear another oath and assuming office fraudulently. To stop printing a given amendment would not have the force of law of repeal of an amendment. Only another amendment can repeal an amendment. There is an amendment to the Constitution that was lawfully ratified, which strips the citizenship of anyone who holds noble title, and made it unlawful for those individuals to hold offices of public trust or profit. While two other sections of the Constitution today prohibit the gifting of noble titles, and the Articles of Confederacy also prohibited noble titles from holding office, we are supposed to believe that this is some conspiracy theory. But this amendment was discovered in an 1825 copy of the Constitution, authenticated and found in the Belfast Library off the coast of Maine. The printing of an amendment by a legislature is prima facie evidence of ratification. But again, even without this amendment, it is still self-evident that it is unlawful for attorneys to hold offices of public trust or profit. Judges, mayors, governors, sheriffs, anyone who swears an oath of office cannot have sworn allegiance to England. If the Second Amendment were no longer printed, it would not strip your gun rights. Our rights exist independently of the Constitution, and even the Declaration of Independence. Our rights have existed in common law for hundreds of years in advance of the Constitution. The Constitution is not even binding upon the people, only the government created by it. The people are bound by common law to obey each other's rights. The people never bound themselves to the Constitution. You will see clearly that all of the signatures on the Constitution are in witness. Witnesses are not bound by the terms of the agreements that they witness, nor are they signatories to those agreements. They are just witnesses. So only the government is bound to obey the Constitution, while the people are bound to obey the law. The Constitution is an instrument of common law procedure, divinely inspired by Deuteronomy and commentary upon Deuteronomy, proven by a 7-year study conducted by the University of Houston, referencing over 15,000 sources. The common law, this supreme law of the land, that which is actually law, is the individual rights of the people, and law enforcement is the protection of the individual rights of the people. As such, a crime is always and only a violation of the rights or property of another, and an infraction is a violation of the terms and conditions of voluntary civil adhesion contracts. Sovereignty is simply the highest authority. All Americans are equal. All are sovereign, the highest authority over themselves and their affairs, until they cause actual harm to another. All Americans are inherently self-governing. So it is self-evident that in order to claim and exercise any right, one must be able to fulfill their duty to ensure no harm comes to another through the claim and exercise of those rights. Responsible, law-abiding sovereign inhabitants of states are not these sovereign citizens in this group, but some who erroneously refer to themselves as sovereign citizens are sovereign so long as they are law-abiding. I, as well as all of my readers, make it our personal responsibility to ensure the safety of all others, including peace officers, in public. The self-governing kings and queens that we are must safeguard the rights of our brethren and respect all as equal. Anyone in a common law jurisdiction can claim and exercise any right which causes no harm to another. And in this self-governing constitutional republic, no majority can vote away the individual rights of the people. I welcome anyone to do the research, to learn the law, and I now challenge you to refute me if you can, debate me if you dare, but by all means, use proper citations of law. Thank you very much, and have a good day.